And you may proceed whenever you're ready.
Okay, great. Ms. Rosin, so in your business of attorney fees, I thought that the business of lawyering was that to be of equity for all parties involved. How can you, in your right mind, justify charging somebody $10,000 chasing $1,000 fee? So, in other words, you are literally billing over $1,000 piece of work that was already done. How do you justify that?
Mr. Woodford, I would direct you back to the statute, which allows a person who files a motion for any person who's adversely affected by frivolous conduct to file a motion for an award of court costs and attorney's fees and other reasonable expenses in connection with the civil action or appeal. We have provided this court with case law and authority that would permit the court to award appellee not only the costs associated with through the dismissal of the appeal, but also costs incurred associated with the motion for frivolous conduct.
But
so that is why a full-time ledger has been provided in the form of Exhibit E, along with the hourly rate there were 2 attorneys and 1 paralegal that worked on this matter. And so that's why the ledger was provided through, I believe it was last Tuesday. It hasn't been updated since last Tuesday.
Frank Mackey, he's a non-party, Alex Mackey's dad. Why are you talking to him and billing me, expecting me to pay for you to talk to him? It looks like about $1,500 worth of attorney fees. Why are you consulting with a non-party and billing me? That's the question.
Your Honor, I'm going to object in that that's privileged information along with attorney work product working with the client.
Sustained to the extent that it would require disclosure of attorney-client information, but to the extent it does not, I am going to require you to answer it.
Your Honor, I would say that initially this court knows that Mr. Mackey also has an identical CPO. And so at the beginning of the retention, both were potential clients to address potential appeals. Also, I feel comfortable with saying that at all times, Mr. Frank Mackey as appellee's father served as an agent or an intermediary. He attended all meetings with the appellee, participated in telephone calls with the appellee. And I was permitted to speak with Mr. Frank Mackey if appellee was unavailable to speak concerning the case.
So what you're telling the courts is that pretty much Frank Mackey is a 50-year practicing attorney. Now he's retired. Is that correct?
I have no personal knowledge as to how long he practiced. I do know that he's retired.
Did you know that he was an attorney?
Yes.
Did you know that?
Yes.
Did you know that he ran for the municipal court environmental judge and lost to Mr. Hawkins? Do you know that?
I did not know that. I first learned that during our hearing on Tuesday.
Okay. And so you're telling me that in absence of Alex Mackey being available to talk, you spoke with his dad, Frank Mackey, about his case and charged me?
Yes.
You need to explain to this court and myself how you do that. He's a non-party. He has absolutely nothing to do with this appeal. He has nothing to do with the dismissal. Would you please explain what you're doing?
Mr. Woodford, I think that there is absolutely nothing improper with a client having a family member participate in the case and providing authority to the attorney to speak to the family member, or it might be a business affiliate, an associate, a friend, a colleague. And so that's certainly within the client's ability to do, and such happened in this case.
So if Frank Mackey wanted to call you whenever he wanted to call you, just to talk to you, ratchet up, again, this is Frank Mackey who went, again, this is a very contentious battle from other lawsuits pending. This is the same Frank Mackey who knows ploys and tactics to use to try to bankrupt a client by getting them to pay excessive attorney fees. Did you know that Frank Mackey is a racist? Yes or no?
Mr. Woodford, I have no knowledge as to anything relating to that question. And I will tell you, as to your previous statement, all of the analysis, all of the legal work, all of the writing, all of the decisions that took place in this case were mine and mine alone.
Really? Is Frank Mackey practicing law without a license? That's the question.
In my opinion, he is not.
He's not. I have seen evidence where I have evidence of where he's been in various situations practicing law without a license. So I guess my real question, what's really troubling for me, is that what you're telling me now, again, I am a black man who's been discriminated against by Frank Mackey. I have had protesters out in front of his building because Frank Mackey will not fix my leaking roof for 10 years. He's a board member. He went out and told one of the protesters, we don't have mice or rats or leaking roofs, but every now and then a rat will get in this building and we'll take them out back and hang them so their other gang members will know what's going to happen to them. I have that documented. It's in the courts, Franklin County Common Pleas. If that is not a racist statement in this climate today, I don't know what is. So for you, so it's not beyond my understanding that Frank Mackey would do anything in his power to ratchet up these attorney fees to break me so I wouldn't have attorney fees available for my other case. I have a true problem, Your Honor, with her talking to Frank Mackey and billing me. So here's the deal.
Mr. Woodford, that is a legal argument and you are fully within your rights to make those arguments. But I'm going to ask you to limit this time that you've got to asking questions of Ms. Rosen. And I am going to give you a full opportunity to make any arguments that you want at the end of this.
I appreciate it. So, Ms. Rosen, in your right mind, you're telling me that if you decide to call Frank Mackey today to discuss this case, not Alex, you're going to charge Alex, correct? Yes or no?
I'm sorry. I mean, I want to make sure I understand the question.
If Frank Mackey calls you today and wants to conference with you with what happened today, and that conference, because I know Frank Mackey's very winded, and if that conference is 2 hours or $550, you're going to charge Alex that and expect me to pay for it, correct?
Yes.
What were the discussions with you and Frank Mackey? What did you guys talk about on this? Let's go to this one billing. What was the nature of your conversation?
Mr. Woodford, I'm sorry to interrupt you, but if you are referring to specific entries, if you can let us know the date of those entries, and again, I'm going to ask you to limit it to any time before June 26th.
It's her, I guess it's her exhibit G, and it looks like this one here is 720, a conversation, it's line item 188067.
Let me stop you there then, because that is beyond the date we're focusing on today.
That's right. Okay. So, Ms. Rosen, prior to the $1,000 of billing, how many conversations did you engage with Frank Mackey relative to the $1,000 that was charged relative to the dismissal of the appeal?
In looking at the ledger exhibit G from February 7th, there was a meeting with both Mr. Mackey and appellee Alex Mackey. So that would be one. Looks like there was a telephone conference with Frank Mackey on March 3rd. And forgive me because I don't know the dates off of the top of my head, but I know that the appellate deadline for Alex Mackey's CPO was different than the appellate deadline for Frank Mackey's CPO. And so there was a time there in the beginning where I was potentially being retained to represent both of them on two separate appeals. So that time may have been, and again, I can't remember the dates off the top of my head, but that time may have been related to your failure to file an appeal of Frank Mackey's CPO. And then quickly glancing over the rest of the time entries for the time entry in question from February to June of 2020, I don't see any other time entries relating to Frank Mackey.
Okay, and okay, so when you found out that you were not going to be retained by Frank Mackey, what conversation did you have with him about Alex Mackey?
The only conversation that I can remember is from our initial meeting that I would potentially represent both of them in two separate appeals. Subsequently, Alex Mackey made it clear that if he was unavailable and I needed to pass along information or to get some authority, that I was free to talk to his father.
Okay, okay. Let me move on to Exhibit 12. Tell me about this case in which your firm obtained a judgment against Justin Honus, a default judgment, and then you all backtracked after an attorney of mine. Justice Honus, first of all, is a client of mine. He needed help. I referred him to an attorney of mine who won about 95% of the motions filed in my 2015 lawsuit against Mr. Mackey. So I connected those two. And you please explain to me how your law firm obtained a judgment, and then you went to court, and that judgment was vacated. When this man retained a very good attorney, your law firm backed all the way down and vacated the judgment. Would you please explain that to the courts? Because I'm looking at conduct and how your law firm operates.
Your Honor, I'm going to object as this is outside the scope that you have set for this hearing.
Sustained.
Your Honor, I'm trying to get to conduct and pattern of her law firm.
Well, Mr. Woodford, the only issue before this court today is whether there was frivolous conduct in the filing of the appeal,
okay,
and whether the fee of up to the date of the dismissal, whether that should be awarded.
I'm done. How much time have I spent on her?
You have 5 minutes left.
Okay. Ms. Rosen, so you are in your right mind. You're telling me that there has been frivolous conduct. Point to, I guess in my mind as a non-attorney, point to what frivolous conduct is in your mind. What is frivolous conduct?
All I can do, Mr. Woodford, is point you to the statute that we've talked about a couple of times. It is, and rely on our brief. In the statute.
I'm not talking about the statute. I said in your mind. Okay, let's forget about the statute. I'm asking you, what is frivolous conduct?
Mr. Woodford, I don't have any opinion separate from the definition of frivolous conduct that's in the law.
Okay, okay. Well, I tell you what, we're going to see how this thing plays out with your attorney fees, but we very well may see each other at the Ohio Supreme Court as well when I file my complaint. So, against your law firm. So that's all I have for her right now, and that's that.
All right, and Mr. Woodford, you will have 4 additional minutes if you choose to use it. Ms. Rosen,
Okay.
is there any redirect that you would like to present to the court?
No, Your Honor.
All right. Mr. Woodford, you have now 30 minutes for your own direct examination. If you will please raise your right hand. You solemnly swear or affirm that the testimony you're about to give this court will be the truth and nothing but the truth, either under penalty of perjury or so help you God.
Yes, I do.
All right, and you may begin. You've got 30 minutes if you wish to use it all.
Okay. Thank you, Your Honor. What I'd like to do here today is to establish the simple fact that Alex Mackey, this is personal, okay? This is racial. Frank Mackey is a racist. He despises Black people. What this thing is, it's more than just appeal dismissal. This is an ongoing litigation extension in which one of their theories, one of their strategies is to financially break me so that I dismiss the bigger lawsuit that's been going on for somewhere in the neighborhood of 8 long years. One Black man suing 35 white people, okay, and 2 Black people due to some very serious allegations. Now, this appeal itself was done in order to employ another strategy that myself and my attorney that I retained, okay, mistakes were made. I am not an attorney. I want you to go to Exhibit 19. Exhibit 19 is me and my family being on the front page of the Columbus Dispatch, being Black, living in Bexley, Ohio, which is predominantly white. The point I made earlier is that my wife and I have 5 kids, and we're very, very keen on education. We moved out of a 3,000 square foot home to a home nearly half the size so we could educate our kids to one of the best school systems in the country. We believe in equality and fairness for all, but we also believe in education. What has happened here is that we have a bigger problem with the Mackeys in terms of a building that we own, a penthouse. Our roof has been leaking for 10 years. And a woman who's on the board has on the same floor, her roof was replaced, repaired as necessary. Alex Mackey is the president of this association. He's refused to replace our roof. We pay an astounding $2,100 a month in condo fees. So when I sued them to get some kind of justice, my 2012 suit, and then I dismissed it without prejudice to come back in 2015 to include the roof. Mr. Mackey was the president at that time, and he still is. And he refuses to restore my roof. He has blackballed me. He's disrespected me. He's called me names such as nigger and the like.
Your Honor, I would
This
request
man,
Your Honor, I would request a limiting instruction that the direct examination being offered by Mr. Woodford stay within the scope of what we're here to discuss today.
Mr. Woodford, I am going to ask you to limit your testimony to whether or not conduct was frivolous and to the legal fees incurred prior to the date of dismissal.
Okay, I was trying to give a history as to the harassment that they're placing harassment against me. I'm not the one that's harassing anyone. I am the one who's the victim here. Okay? As I said before, the fees of $1,000, the American rule is very simple. You pay your own attorney fees. Okay? You pay your own attorney fees. I've sat here and listened to their hogwash relative to frivolous conduct. Again, I'm going to point to my other lawsuits. On the 2012 case, I prevailed on 80% of the motions filed by either side. The 2015 case, I prevailed on probably 95% of all motions filed by either side. Now, here we are. Again, I point to this here. These are my kids. My wife passed of cancer 4 years ago, tragically. I do not have the time to be involved with frivolous conduct, ma'am. I don't. So what they're alleging is ludicrous. It's outrageous and it's absurd. And what they've done is they've taken $1,000 worth of attorney fees and they've ratcheted them up. Will be past probably $10,000. They've got a non-party, a former judge, a gentleman who practiced law for nearly 50 years, Alex Mackey's daddy. And the thing about this, Alex, daddy's got to take care of this grown boy. It's 40 years old. He's on the board of Park Towers because he can't do the job. He brings his daddy on board, who runs everything. So what's happening here today, this is being fueled by Frank Mackey, not Alex Mackey. I do not owe anything in attorney fees. The American rule is very clear. All parties pay their attorney fees. Section 2323.51 does make an exception to that when they talk about frivolous conduct. Me filing an appeal of a bogus stalking order in which they lied under oath on that, I did not know exactly which approach I was going to go. And when I went down to file the appeal, I made a mistake and didn't file against both of them. It was a mistake. I'm not an attorney. That wasn't frivolous. That wasn't meant to harass anyone. And what happened was I retained an attorney, a very good attorney, Bruner. Okay, and I'm paying nearly $500, almost an hour. Okay, for Rick Bruner to represent me. And it's in the dockets. Okay, it's in the case. Now, I don't have money to waste. They have paid on that first those other lawsuits, nearly $600,000 in fees. I spent about $200,000 representing myself. They have insurance money, as he testified, to fight me. I'm paying my own money to represent myself or attorneys. So what I'm suggesting is this is just another strategy. When you don't have a good case, as they don't, they thought they would bury me 8 years ago. I've been fighting for 8 years, one black man against millionaires and quote unquote powerful people. Guess what? I'm winning. They haven't buried me because I am deeply rooted on a solid foundation on all my cases. Now, the fact is, I don't have the time nor the desire to harass Alex Mackey. He's nobody to me. He's a liar to me. He's a criminal. He's perjured himself on many occasions, and I'm going to prove that. This is personal, is what I want this panel to understand. I've done nothing wrong. I have done, even with this bogus protection order, I have complied with that it was 1 year, and then because of Frank Mackey's clout, he's got it turned to 5 years. While we're still paying $2,100 in condo fees and we have a leaking roof. If I was frivolous in any filing, Judge Holbrook ordered Frank Mackey and Alex Mackey to restore my roof earlier this year. February 10th or 28th, the order went down to restore my roof. That means I won. I prevailed. Alex Mackey has failed to restore. He's in contempt of court. So what I'm saying to you, I have bigger fires to deal with. Filing a frivolous lawsuit or appeal is nothing I have time to do. They have not proven my conduct was frivolous. They're entitled to nothing. I was going to go say that section 2323.51 does give latitude to this court to impose reasonable attorney fees if frivolous conduct has been found. These fees of $1,000, that can be questioned whether they're reasonable or not. But by the time Miss Rosin gets done and Frank Mackey gets done, who was a defeated candidate, he's still bitter about that. When they get done with her attorney fee schedule, it'll be in the neighborhood of $12,000, $13,000. Chasing $1,000 fee, that's wrong. And to me, it's illegal. But what I'm saying to this court, any attorney fees they're seeking are not warranted. This is a strategy to break me financially. So in the other case, I will go away. That's all this is. It's a strategy. And you all know that in today, it's unfortunate that the judicial system today is where it is. When attorneys don't have a good case or they have a loser, they will try to ratchet up and file all these bogus motions and what have you to run up the other side's, cost. That's a strategy. And that's the strategy they're employing here today. Alex Mackey has no basis for any attorney fees, none. He hasn't proven that I have been frivolous because my conduct's not. I made a mistake. I talked with a very prominent attorney, Rick Bruner in Columbus, Ohio, retained him, looked at my options, and I decided to pursue that stalking just like she got, and I don't mind sharing this. I'm going to file a motion to have that vacated. That judgment entry dismissed, vacated. That is my strategy next. So there was no need for me to go on with this appeal and spend tens of thousands of dollars on attorney fees. I'm spending my money elsewhere, and I have a strategy with my attorney to have that stalking order vacated. Just like this case with Miss Rosin, they had a judgment vacated. When they were proven wrong, they vacated that judgment. And that is my plan. So it wasn't to harass anybody, as Alex wanted to, assume. These are assumptions. He makes these allegations. Well, you didn't go after one, but you went after the other. That's harassment. No, it's not. No, it's not. He is a dreamer. He doesn't get any of this. He's a liar. He testified, I've never been in court before. This is my first round. I wanted to move you all to exhibit, let's see here. This is an exhibit here where Mr. Mackey he'd been foreclosed on, okay? He had made a comment that he, under oath, that he had never been involved with any court business. Well, I'd like you to go to, let's take a look at Exhibit 13. That exhibit there speaks to his judgment that was placed against the 08 judgment case that was placed against Mr. Mackey. And he had a motion was filed for him to do a debtor's examination because he refused to pay his judgment he owed to the state of Ohio. Now that is Alex Mackey, the same one that stated that he had never had any been to court, or this is all new for him. He lied. He lied. Exhibit 13 right here is a motion that was filed to compel Mr. Mackey to show up to court. You show up to court because he would not pay his state of Ohio income tax in the amount of $2,183.15. He had to waste the court's time, okay, and charge all this interest because he did not pay his state of Ohio income tax, okay? So when he said he'd never been to court and all this was new to him, he perjured himself. the next thing I'd like to discuss is this foreclosure action. Mr. Mackey was involved with a foreclosure case being Exhibit 17.
Your Honor, again, I don't take interrupting Mr. Woodford lightly, but I would respectfully request another limiting instruction just so we could keep focused on this case and the fees that are requested.
Again, Mr. Woodford, this is we have limited this hearing to whether or not the conduct was frivolous, fees up until the dismissal.
Okay, what I'm
So I
trying
am going to give you some leeway and let you introduce any evidence that is pertinent and relevant to those two issues.
It's relevant because I'm trying to introduce evidence to show Mr. Mackey's a liar. He's perjured himself under oath, and I will be taking the necessary actions in court. I want him to be found in contempt of court and also perjury. I'm going to pursue that. So I'm introducing this information to show the panel that he is a liar. He has lied under oath, and I want to take the necessary measures to move forward with prosecution of these charges against him. I'm about contempt of court action, and again, I'm talking about perjury. So again, before she disrupted me, Exhibit 17 is a foreclosure action that was filed against Mr. Mackey. Mr. Mackey had stated on the record he had never been involved with any court. Oh, in my life, I've never been involved with any court proceedings. Well, I said right here, the foreclosure case where this is worse. He was actually the guardian of some estate, and he allowed the property to go into foreclosure. That's what Mr. Mackey did. So, you know, again, he claimed to be some, you know, oh, he's gay and he's, you know, this and that. We don't care about any of that. The problem with him, the problem I have with him is not him being gay. He admitted that he was gay. No one cares about that. But here's what I care about, is that he's highly opinionated. He doesn't like black people, and he is using me as an example. If you go against Park Towers, we're going to hurt you. We're going to make an example out of you. And he even testified about these fees. I said, why didn't you leave it alone when it was $1,000? He made the comment that he wanted me to pay so I don't do this again in the future. See? So this is part of their overall strategy. Their strategy to break me with Frank Mackey, the racist that he is, fueling the fire. And so I think that we have to examine his conduct. Frank Mackey is practicing law without a license. They've teamed up on me. And this attorney, Rosin, she's been used she's just a pawn. That's all she is. She's doing what Frank Mackey has ordered her to do. So I'm not happy about this. Again, he's brought no evidence to bear that I was frivolous in my conduct. I'm a very busy man. I'm in real estate, and one of our chief maintenance techs became ill. I had to take over 35 properties to manage. Have investors and clients I work with. I do not have the time to be frivolous with this man at all. I want this court to know I've got kids in college, 2 at The Ohio State University. One is on an academic full ride scholarship. She's involved with Black Lives Matter. She protested from Bexley, Ohio. She took 2,000 people to the State House. She's been on the news. She's been in the paper. She's been on the front page of the Washington Post, the Columbus Dispatch, all the local media here. I am raising children to be productive in a society in which racism exists. Okay? My one daughter graduated from the University of Cincinnati, came out of Bexley High School with a 4.25. The one I just mentioned came out with a 4.99. My oldest daughter is at Price Waterhouse. She's an auditor, a CPA. 1% of those of African Americans have that designation in this country. My other daughter is graduating Ohio State University, scholarships and what have you, early with a 4.0. My other daughter, 4.0. I don't have the time. A single father to play with a guy like Alex or Frank Mackey. I have to raise these kids to be productive citizens and make it in America in spite of racism. And I've taught my kids what I'm preaching here. Fight for what you believe is true and what is right. And when you're wrong, admit it. And the problem with Alex Mackey, he's a stubborn person, just like he wouldn't pay his $2,100 state of Ohio income tax. He made them do a debtor's examination of him because he was going to dig in and fight. Well, that's what he's doing here. He's refused to fix my leaking roof on a penthouse. He wants to steal the property from us. It's racism, and you have to understand what their motives are here, Your Honor. I mean, this is not good. No way could it be fair. They've taken $1,000 issue and they've ratcheted up to probably 12 to 15,000. That's wrong. That is wrong. So what I want to say here now is that, again, they have failed to prove their case. There's no malice. There's no harassment. There's no motive. There's nothing. I filed an appeal by myself, sought legal counsel, Rick Bruner, one of the best attorneys in the country, and we decided another strategy would be employed. That's why I dismissed the appeal. I did not file a brief. I didn't force them to file a brief. That would probably cost him, what, $4,000 or $5,000. I didn't do that. If I was out to harass and be frivolous, I would have filed a brief. I'm smart enough to know what that is. Mr. Mackey said I was a smart man the other day. Said I was very intelligent. Well, does he think an intelligent, smart man would waste the time to file a frivolous conduct, be frivolous and exhibit frivolous conduct when he's marrying, when his wife he's been with, a woman of 32 years has passed, and with obligations that he would never imagine because he didn't have any kids. It's just himself and I. He's got no idea. So in his little world, make-believe world, people have nothing to do except bother him. No, I have 5 kids to raise to become very productive citizens, to stay off drugs and alcohol. Unlike Mr. Mackey, he drinks alcohol. He smokes
Mr.
weed.
Woodford,
Okay.
I am going to stop you there because this isn't about either person's character or all we're focusing on is whether
Okay, I'm just
conduct
trying
was
to get the
frivolous.
court to see they're doing this to me as part of a strategy because he doesn't like me. Okay, he doesn't like the fact that a black man owns the biggest penthouse in that building. That's the issue here. So it's nothing I've done to go attack him, to be frivolous. I'll have my day in court on those other cases. I'm okay with that. But they have failed to prove any conduct that is, again, frivolous or with the intent to harm him or anything of that magnitude. So I want to leave it there for now and save my minutes because I have more questions for Mr. Alex Mackey. And also, I'd like to say this: if Frank Mackey is there, I'd like to get him. I want to swear in Mr. Frank Mackey. He's there. He's part of this. I want him in.
All right. Well, you have 7 minutes left and then 4 from before. Do you have any cross-examination, Ms. Rosen, of Mr. Woodford?
No, Your Honor.
All right. Let me back up for 1 minute, Ms. Rosen, because I never officially asked you if you had any additional witnesses to call before I allowed Mr. Woodford to call himself. But I know you had originally gone through your witness list with us, which is why I did that. I assume you did not have any additional witnesses.
That's correct, Your Honor. And the only thing I would ask, and I didn't know if it was your preference to do it at the conclusion of our testimony or at the end of the proceeding, would be to admit our Exhibit G to the record. But other than that, we rest.
All right. Is Exhibit G the only exhibit you're offering?
Yes, Your Honor. It's the attorney fee ledger.
All right. Mr. Woodford, any objection, not to the content of Exhibit G, but any objection to the admission of it into evidence?
No, Your Honor.
All right, it will be admitted. Mr. Woodford, you do have a little bit of time left. Would you like to call any additional witnesses?
Yes, Frank Mackey.
All right.
He's not in the room or near. Do you want me to go out and see if I can bring him in here?
Let me first ask Ms. Rosen, is there any objection to the calling of Mr. Mackey?
If I might have a moment, Your Honor, just to consult with my client, could we perhaps take just a 2-minute break?
Yes, but I will say that any witness who has any testimony to offer on the limited relevant issues that have been raised, I will permit. I don't know if that includes Mr. Mackey, but Mr. Woodford, I would also tell you that, again, it's a very limited examination of any witness in this case.
Got it.
Right.
All right, let's do a 2-minute recess. Mr. Souter, if you can place everybody into the waiting room again.